We're going to move on to Delegate Grammer's bill, and that is House Bill 548. Delegate Grammer, it is titled Public Safety, Militia, Active Duty Combat Defend the Guard. Will you be so kind and bring your panel? I believe you have Dylan Griffith, Amy Laporte, Dan McKnight.
Scott Spalding. Dylan couldn't be here, so if I could swap him out, if that's okay.
Scott Spalding is here.
Yes, ma'am.
Will you come up, please?
Yes, ma'am. Here.
And Dylan is not here, okay?
Dan McKnight should be virtual.
1 second. Yes, he is virtual. And then I have another person, Jason Laird.
Jason Laird.
Yes,
That's fine if he's here.
okay. All right.
There we go. I'll get started with your
Yes,
permission.
please. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, for the record, Delegate Robin Grammer here to present House Bill 548, the Maryland Defend the Guard Act. House Bill 548 limits the use of Maryland's militia to constitutional deployments. Today, our U.S. troops are positioned in over 160 countries with military bases in at least 80 countries. Maryland's National Guard accompany our armed forces who are trained primarily for combat in many of those positions. Most Americans are likely unaware that in addition to our current deployments, U.S. troops have recently seen combat in Afghanistan, Mali, Nigeria, Kenya, Somalia, Yemen, Syria, and Iraq. The burdens of these conflicts lay squarely on the shoulders of our sons and daughters. Many veterans suffer greatly from these conflicts. Thousands suffer loss of life or limb, carry the baggage of post-traumatic stress syndrome or other mental health issues. Maryland's National Guardsmen, who are not trained primarily for combat, should be here serving Maryland's communities. 3 days after the Maryland House of Delegates voted against Defend the Guard last session, our very own National Guard was sent to the Middle East, sent to an undesignated location for an undesignated time for an undesignated purpose. Without intervention by our state legislatures, this is news we will hear again and again in the coming years. The Defend the Guard Act attempts to deal with this problem. It does so by limiting the deployment of the Maryland National Guard to the constitutional deployments, including declarations of war and deployments governed by Titles 10, Civil, and 32, Invasion and Insurrection. Justifications for our foreign engagements should be clearly defined so that both the public and our service members understand what our goals are. Our service members should be guided by clearly defined victory conditions. Mission accomplished should be a predefined goal, not a banner to stand in front of for a political victory. Although the Attorney General has written a letter discounting the bill, he is ignoring federal law. Title 10, Sections 12301 and 12302 provide specific and enumerated purposes for federalizing the National Guard, none of which include participation in undeclared foreign wars outside the continental United States. The Attorney General's reliance on Sterling versus Manasian does not support the claim of federal supremacy over governors in blocking unauthorized deployments as it pertains to federal administrative control and not foreign combat operations. We should defend those who defend us. With that, I'd be happy to take questions, and I'd ask for a favorable on House Bill 548.
Next, please.
Very good. Madam Chair,
Yes.
thank you for your time today.
My
I
pleasure.
appreciate this. Absolutely. It's good to see the committee. So when serving in the Maryland Senate constitutional law attorney, I certainly can. I apologize. I'm Dr. Amy Laporte. You probably all know that name well. You're probably sick of hearing from me. When serving in the Maryland Senate, constitutional law attorney Jamie Raskin said, a crucial part of our constitutional design is to make war as unlikely as possible. That same year, he introduced a bill much like this one, urging Congress to do its job, to declare war if war is necessary. He understood that doing so would mean less war and that calling up our sons and daughters would be reserved for a worthy cause. Raskin also knew that the Maryland National Guard plays a critical role at home, and that's what I'm here to talk about today. I stand before you with an urgent plea that the National Guard must remain in Maryland to protect our communities unless Congress calls them to war. As a former president of the Maryland Emergency Management Association, I have dedicated my entire career to emergency management, guiding Cecil County through presidentially declared disasters numerous times, and I have seen firsthand the National Guard's incredible impact. They are a lifeline for communities in crisis when they are there. Disasters don't discriminate, you know that. The most vulnerable suffer the most. When Maryland lacks full preparedness, low-income renters are displaced longer, and people in poverty struggle twice as long as everyone else. You might ask whether or not we've ever compromised our ability to protect Maryland. The answer is yes. During Hurricanes Isabel and Sandy and Tropical Storm Lee and the devastating flooding in Ellicott City, Maryland did not have its full guard force. They were in Afghanistan, Iraq, Egypt, and other locations in the Middle East. House Bill 548 is not just a piece of legislation. It is a mandate to ensure that Congress fulfills its constitutional duty. This is not an abstract issue. It directly impacts Maryland. And on behalf of all Marylanders, we must safeguard our National Guard and support House Bill 548. Thank you so much.
Thank you, Dr. Lepore, for your testimony. Who will be next, please?
Good afternoon, Madam Chair, Madam Vice Chair, Committee. Thank you. For the record, my name is Scott Spalding for District 46. I'm a Marine Purple Heart recipient, Guard member, although I am not here to speak for the Guard. I'm sure the General is here for that. And I'm a teacher in my civilian career, and that's the capacity I'm here to speak in. Yesterday was President's Day, so I'd like to mention some quotes from some presidents. President Washington said, "The Constitution has the power of declaring war with Congress, not the executive." Madison warned the trust and temptation of war was far too great for any one man. Lincoln said kings had always been involving and impoverishing their people in wars, so the Constitution was framed that no one man has this power. Yet for the past 24 years, presidents have sent our National Guard to fight in 20 different countries, and 95% of Congress is no longer in, 95% of the congressmen was not in office when the AUMF is passed, meaning that these wars have outlasted a congressional career. Let's consider the cost of these wars, because we're going to hear about funding or whatnot. Last year, my school and several police departments, as well as other schools across the state, were shorthanded because of that deployment that was mentioned. At Towson University, after my first deployment, I sat next to a young man who looked like an Iraqi that I had helped place into a body bag, and I had to withdraw from that class. And I'm sure I'm not the only case. There's also worth considering the cost to other people. The Iraqi family that was shot to pieces during a firefight I was in, the baby who lost an eye to our bombs in 2004, the Afghan 7-year-old whose legs were blown apart in 2014. Explosives are not surgical weapons, despite what anybody might tell you. And these children would be the same age as my students from Parkville High School, students from Yemen, Iraq, Syria, and Somalia. All of those countries have been bombed in the past month by the United States or our allies. Is it right for one person to decide to wage war in 20 countries for 24 years?
You can take your time. Go ahead.
I'll try to be quick. Regarding constitutionality, I think we should follow the correct democratic process. Georgetown professor Jamie Raskin said this bill strikes him as a meaningful and viable claim, meaning constitutional, about the rights states maintain under the Constitution. And if there are any issues, I hope it's the committee's role to help work those out and perhaps craft a bill that would pass muster. And I'll conclude with just the fact that this should never be a partisan issue. Jamie Raskin supported this under Obama. Delegate Grammer supported this under Trump, Biden, and now Trump again. This isn't a partisan issue, and please don't make it one. And lastly, no dollars could bring back my friend whose orphan twins never got to meet him. So when we're thinking about costs, or that comes up, remember all the costs to the children in my school who suffered through things and other Marylanders. Okay? Thank you very much.
Thank you for your service, and I'm sorry about the loss of your friend, okay?
Thank you as well.
Thank you. Next, please.
Good afternoon. My name is Jason Laird.
afternoon.
Good afternoon. My name is Jason Laird. I live in Frederick, Maryland, District 3. I'm here today in favor of HB 548, and I need my glasses. Before 9/11, when folks... I'm sorry?
I can't read without my glasses.
Before 9/11, when folks signed up for the National Guard, they understood that they may be deployed for days or weeks at a time in Maryland or neighboring states for natural disasters and other domestic crises. They did not expect to be deployed for months or years at a time on the other side of the world fighting a hot war in a strange place. That's unexpected time away from their families, their employers, their small businesses for much longer than ever before. Well, this session, you have a chance to do something about this situation going forward. As I prepared to speak with you today, I wondered how your constituents would regard you if you failed to act when you had the opportunity to act to prevent this from happening again. Imagine if this president or the next one wants to send our National Guard into Iran. How many of your constituents would be excited and overjoyed at this prospect? If you fail to act on this legislation, we will let them know that you had the chance to do something to put up a roadblock in front of the administration, but chose to do nothing. Now imagine another scenario, one in which our governor tells the president to go pound sand. He can't have Maryland's National Guard unless Congress officially declares war. How much more satisfied would your constituents be in this scenario? Please defend our National Guard from the prospect of another misadventure in the Middle East or elsewhere. Please work for our National Guard families. Please work for your constituents' interests. Please do your part for our country. I'd be happy to answer any questions you might have. Thank you.
And thank you for being here. We really appreciate. We have a virtual witness, Dan McKnight. Will you be so kind and bring him up, please? Thank you. And everyone that's waiting for your bills, I know it's been a long day. We have tried to be as fair as we can in calling these bills, so just bear with us, okay? Good afternoon, sir. Mr. McKnight, will you be so kind? Welcome to the Health and Government Operations Committee and provide your testimony.
Thank you, Madam Chair and members of the committee.
You're welcome.
My name is Dan McKnight. I'm a 13-year veteran of the United States military. I fought in Afghanistan from 2005 to 2007, but today I'm here as the founder and chairman of a veterans organization that spans the entire country called Bring Our Troops Home. You know, every veteran swears an oath to protect the Constitution, and the most important clause in the Constitution governs war. And it's very clear that Congress alone has the authority to declare war. Yet for decades, Congress has abdicated that duty, allowing presidents from both parties to wage endless and undeclared wars. The Defend the Guard Act before you today is the constitutional correction to this failure. Opponents will claim that federal law prohibits this bill, that governors cannot object to the federalization of their own National Guard, but that simply isn't true. Title 10 of U.S. Code states that a member of the National Guard may not be called into federal duty without the consent of the governor, except for the purposes of overseas training. The Supreme Court even reaffirmed this in the Perpich v. Department of Defense case in the 1990s. You're likely going to hear concerns about federal funding and equipment, but members of Congress and the United States Senate have affirmed that these concerns are nothing more than a red herring. Further, the current Secretary of Defense, Pete Hegseth, the Director of National Intelligence, Tulsi Gabbard, and the Director of the Counterterrorism Center, Joe Kent, have all endorsed this bill. Claims of federal supremacy and funding loss are misleading and tiresome, but really what truly exhausts me is seeing sons and daughters, Maryland citizen soldiers, sent into unauthorized wars. We know what war is. Every veteran that supports this bill knows what war is. But what we don't know is what it's like to have Congress actually declare war before they send us, demonstrating their own courage and the full informed consent of the American people. We have a robust active duty military at the president's disposal for limited combat operations worldwide. Defend the Guard does nothing to restrict that authority, but it does demand that Congress fulfill its constitutional duty before sending the National Guard into war. So when do we get to demand that Congress even show an ounce of courage that they expect from those that they send to fight and die? Then I'll wrap up. Those of us in uniform uphold our oath to the Constitution, and it's long past time for Congress to uphold theirs. This bill is Maryland's chance to take a stand and to make clear that the National Guard of Maryland is not the tool for endless and undeclared wars. If Congress wants a war, let them declare it. Until then, our guardsmen should stay home and protect America. Madam Chairman, thank you so much for the time, and I'll stand for any questions you may have.
And thank you for your service. We really appreciate it, okay? And this committee values everyone that serves. I know I have family members they have served. So thank you so much. I'm going to open it up for questions. First, I saw Delegate Riley. And next, I'm going to go to Delegate Chisholm and then Delegate Hutchinson. Okay?
Thank you.
My pleasure.
Yes, whomever is best to answer this, maybe the sponsor. So I think there's a problem, speaking of this, but I do support the bill. Thank you. And speaking about the bill with other folks, I think there's a confusion of the Army Reserves or the, National Reserve, Army Reserves or the National Guard. So I actually you pulled it up and I just put in Army Reserves just to get their definition. And it automatically came up. It says the U.S. Army Reserves and the National Guard are both reserve components of the U.S. military, but they have different missions and reporting structures. Army Reserves support military operations worldwide. National Guard supports state emergencies and homeland defense. Do you agree with that comment?
Generally, yes. Although I would say the Army National Reserves are much different, and that those reserves lay squarely under the prerogative of the president.
Okay. So you do believe that the, obviously, from most of you and your panel said that the National Guard was formed to defend our states.
I'll take that.
Yes, absolutely. We absolutely believe we're here to defend the states and serve the president in time of war. Per the Constitution, there's a separate clause in the Constitution that defines when the Congress may call forth the militia.
Okay.
It's about 2 or 3 below. I think it's clause 13 as opposed to the clause under which in section 8 calls
So this
for.
bill has the exception in there if they are needed and Congress takes action.
Yes,
Thank you
exactly.
very much. I appreciate it.
Delegate Chisholm, followed by Hutchinson.
Thank you, Madam Chair, and thanks for bringing this bill to us and all of us getting our U.S. Constitution 101 today. Because Article 1, Section 8 does clearly say that only U.S. Congress can declare war. So I'd really like to know, how does this play out then? Let's say that, we start to deploy troops overseas and they want to call the National Guard or Guardsmen from Maryland. Would our Attorney General have to stop it at that point? Or how would it work out in real world scenarios? And are we the only state have any other states passed it? And have you seen it actually put into practice? Because pragmatically, I want to understand how it would actually play out.
Yeah, it's an exceptional question, and I feel like it's one that probably everyone here has. So I'll start backwards. And
Only one person.
You're the only one. Yeah.
yeah, no problem at all. I think I can do it. So, to answer kind of the second part of your question, there is this piece of legislation in just about 30 states right now, and those legislatures are working through the issues, much like you are, kind of learning, getting up to speed on Defend the Guard in 30 legislatures across the country. It has already passed in 4 states, but not in both chambers. So in each of 4 states, it has passed in one chamber, and we anticipate that this will be the first year when it passes fully in both chambers and becomes law. The mechanism in this bill and the bills that are in each legislator is the governor. So it is upon the governor to say, you cannot have the National Guard activated for combat deployments unless there is a congressional declaration of war. And that is simply the mechanism. What we anticipate happens next, we anticipate that the federal government, there is a huge concern about funding, which is understandable. What we are sure of is that there still must maintain kind of unit readiness at some level. And so the federal funding is not going away. We have assurances about that. So in each state, it will be incumbent upon the governor, if Congress has not declared war, to simply say no. And that is your authority to use your state militia. And what ultimately ends up happening is that Congress then takes accountability. And if there is a threat to this country and we must send our sons and daughters, I promise you that Congress will declare war, and then our governor can say, absolutely, you can take our units.
Okay. Thank you. Thank you very much.
Absolutely.
My pleasure. Delegate Hutchinson.
Thank you, Madam Chair. Delegate Grammer, I don't know if I dreamed this or thought I saw it somewhere. It's not in testimony, but did the Attorney General chime in about this at one point?
Yeah, he did write a letter. I'd actually like to yield to Mr. McKnight to address the Attorney General's letter, if he's okay with that.
Yes, absolutely. Can you hear me okay?
Yes, sir.
Yeah, so I believe the Attorney General's letter was overly broad, and it didn't really actually dive down into the issues at hand. Specifically, Article 1, Section 8, Clause 15 and 16 of the Constitution grant Congress the authority to call forth the militia for 3 purposes, right? To execute the laws of the Union, to suppress an insurrection, and to repel an invasion. Foreign combat operations absent congressional authorization simply aren't included in that authority. The Attorney General went on to talk about certain federal statutes that don't, that this bill would be in violation of, and those are not true. They talk about Title 10 and Title 32, and I want to be very clear about what those two are. Title 10 is when the National Guard is activated and they're put under federal control and federal dollars. And those are found in Title 10 of U.S. Code, Section 12301, Sections A through F. Okay, Title 32 is when the Guard is called for federal funding under state control. And those are Homeland Defense, emergency response, things of that nature, insurrections, putting in enforcement of law enforcement and things like that. Those two things are two separate codes, two completely different authorizations. And the Attorney General talked about the defunding of the National Guard would be because of a Title 32 removal of funds for failing to meet readiness standards. But that's actually, it's not correct. He's using Title 32 to defund Title 10 missions. And those two things are being misconstrued. You can only defund a National Guard from the federal government if they fail to meet readiness and training standards under Title 32. Title 10 has nothing to do with Title 32, and this bill only deals with Title 10 deployments overseas. And so it was a little bit of a misdirection, maybe a misunderstanding of the difference, because it is a very fine line. But finally, in Title 10 of U.S. Code, Section F, it's called the Montgomery Amendment. It specifically states that for the purposes of overseas foreign training, the governors cannot object to the calling forth of their militia into federal service. It's the only place in the federal code or the Constitution that says for one specific purpose, the governors do not have the ability to interpose and object. And it's only for overseas training. And the Supreme Court reaffirmed that in the Perpich v. Department of Defense decision that already referenced. And then finally, one last thing, there's a couple of instances where governors have already used their authority to block the calling forth of their militias or their National Guard. One was Governor Lester Maddox in Georgia. He refused to let the National Guard go forward. The federal government was unable to overstep his authority. And there was a governor in Hawaii, and I'm dropping her name, that objected to the use of the National Guard to go to the Middle East for the global war on terror because she had crises at home that needed her attention. And so this is not a novel concept. It's not radical unless you look at the actual definition of the word radical, which means getting to the root of an issue. And that's what this bill is trying to do, is to get to the root of the issue, that we have a way to go to war in this country, and that is clearly defined in the Constitution.
Thank you. You picked the right person to answer that question.
Thank you.
Thank you. Any other question for this panel? Since there are none, I'd like to ask a few.
Sure.
First, I want to start with, and usually I tell my members, what is your question? But I'm going to give myself some grace and have a little leeway since I've been communicating with some of you online, okay, and have replied to your emails because we reply to everyone. If the bill does not pass, it doesn't mean that any of these 23 members that do not support our Guard, our troops, all right? Let's just put that on the table, because a lot of us have people that serve and we're very supportive, okay? I want to start with that. Delegate Grammer, if you disagree with the AG, because the explanation given by Mr. McKnight, you can ask the AG to revise the letter. You can connect Mr. McKnight to the AG's office and put them in touch so that they can talk to him, and perhaps Mr. McKnight can give them information that they can use to rely. I've done it, and many other people have as well. Secondly, I asked you last year, why didn't you cross it? Did you cross the bill this session?
I did not.
Okay, is there a reason why not?
The Senate tends to run the train off the railroad tracks, and I tend to pass bills when I don't have cross files.
Okay, because it's good to do it in a bill like this in both houses.
Unless your bill dies in the Senate, and then you're kind of...
So you think it was gonna die? Okay, so the other thing I wanted to clear is that to date, there hasn't been one state in the U.S. that has passed this bill, correct? Not both houses. Both houses and signed by a governor.
Not that we've seen.
All right. In Virginia, it passed the House, but there was no Senate cross-file. In Arizona, it passed the Senate twice. It was killed in the House. In New Hampshire, it passed the House, did not, it died in the Senate. In West Virginia, right next to us, it failed in 2015 and 2024. In Montana, it passed the House. In Idaho, did not advance. Actually, Idaho, as I was doing research for this bill, there's a big article, and the article actually states the following. It's a newspaper article. It says, amid concerns, bill would defund the Idaho National Guard. House committee shelves legislation. They thought it would cost millions of dollars. And I have a reason for bringing this up in a minute. In Texas, it was sent to a study. In Michigan, it failed. It said it will have a fiscal note of over $400 million. In Rhode Island, it was sent to a study as well. It is presently pending in Arizona, Georgia, Kansas, Kentucky, Maryland, Minnesota, Missouri, Montana, New Hampshire, Oklahoma, and South Carolina. But no one has passed it. And did you see, Delegate Grammer, page 3 of the fiscal note?
I did.
And page 3 of the fiscal note, because we don't have to guess, we have to take people at their word, right? I always like to say, I want you to think that I'm coming with my best intentions, and I'm going to assume you come with your best intentions.
Yes, ma'am.
And this is what we were told by the department, Delegate Grammer. Because the fiscal writer called the department. Because when we write a fiscal note, to see what the impact is, they call, and if you've been sitting here, you've been hearing me mention the fiscal note.
Yep.
What the cost will be or effect. It says, notwithstanding federal law, the military department expresses concern of the bill's potential effect on its long-term federal funding. According to the department, the federal government could view any attempt at limiting the National Guard's activation as justification to revoke the department's federal funding and other military equipment and facilities provided by the federal government. So, and then to top it off, we got a letter from the AG, and I checked with them again this year, Delegate Grammer, to see if they had changed their mind. And it's the same as last year, where they said that this will be unconstitutional. So being that they say it's unconstitutional, given that the federal military department told us that, they're concerned about their funding, and being that it hasn't passed any other state, all right? That is what this committee has in front of us, okay? So as you think about things, there's no malice behind what we do or not do. It's the fact that we go on the facts, and those are the facts we have as we decide this bill. Now, what I would like you to do, Delegate Grammer, is to go back to the AG and have Mr. McKnight, who gave an amazing explanation on Article 32, and see if you can get a revised AG letter from us.
Yeah, I'd like to respond to that, all of that,
Sure.
if I can. So I think the sole thing we should remember is that as elected officials, and even state elected officials, the first thing we did when we were elected is swore an oath to the Constitution. And the Constitution is the law of the land which supersedes all other things. And it tells us what to do explicitly, especially on this issue. And in that, it is very clear. And in that, knowing that.
But excuse me, but you're disagreeing with the AG. Can we assume that you're disagreeing with our AG, right?
Unequivocally, I disagree with
Okay.
the AG. And I think the fact that so many other states have failed to take leadership on this issue means absolutely nothing to me. And I'll give you the reason why this very issue is not only in our Constitution, but has been discussed for hundreds of years. The gentleman named Dylan, who couldn't be with us because he had to work today, served in Afghanistan. In the war in Afghanistan, there was a particular deployment, which was the bloodiest battle for the National Guard in American history. The National Guard had to set up before those who were trained primarily for combat arrived, and they lost scores of troops. It was an unconstitutionally declared war. It lasted over 20 years. And at the end of that conflict, our armed servicemen, if you listen to their stories, they walked away and they said, what did I even do with the last 2 decades except look to my left and my right and see my brothers and sisters die? I can't go back to their families and even explain why we went to that conflict in the first place. So I would cast the Attorney General's letter aside because it's wrong, just as he has been wrong so many times. And I would say this committee should be empowered in this moment to be the state that stands up. You know, Democrats and Republicans used to be skeptical about war because what happens unequivocally in every armed conflict over the last 44 years that I've been alive is we walk away without a real answer why we were there, and we have nothing but broken and battered families. So this committee can be the first to stand up and for this radical idea that, sure, you could take our National Guard away from our communities to serve abroad. Just tell us why you're doing it. What we're asking here is you just make Congress do its damn job, which in 2025 seems impossible. I get it. But all we're doing is we're taking our constitutional oath, we're taking it seriously, and we're saying before you cast the lives of Maryland's National Guard men and women, you just tell us why we're going, you do your job, you declare war, and we're happy to be right there with you.
And I know you disagree with the AG, but we follow the AG's, advice. I have one last question, Delegate Grammer.
Yes, ma'am.
What is the difference between the bill that Jamie Raskin was a co-sponsor, not a lead, the difference between that bill and your bill?
So then State Senator Raskin filed bills in 2009 and 2010. There are negligible differences. I cannot cite them. We can certainly continue to, I know I have tried to share with as many of you as possible so you have the historical understanding of what has gone through the legislature. There is negligible difference, but I'm happy to work with Delegate Grammer and define that better.
So I'll tell you what the differences are because I have them in front of me. So if you look at Delegate Grammer's bill and the bill that Delegate Raskin 571, which is the bill you sent me by email, and thank you for sending it to me. I read it. Delegate, the Raskin, he was a co-sponsor. This is the difference. His would apply if an authorization for use of military force has its terms expire, or is no longer valid authority for federal control over units of the National Guard, and there's otherwise no action on the way for the prompt return of the units to the state control. The governor shall request the returns of the units to the control of the state. There's a big difference between them because that means that it has expired, right? Yours is preempting it, right? There's a big difference between both of them. There's very different bills. And if you can read it again, you don't have it in front of you, you will see that. And I'm referring to line 12 to 19 on page 2 of Senate Bill 571, okay?
And those are the details which I regard as negligible.
Okay.
Surely this body does not believe that an authorization of military force signed in 2001
Fight Al-Qaeda.
still to fight Al-Qaeda still applies and permits us to continue to send men and women into harm's way when Congress will not do their job and will not declare war. I don't think you believe it. I think you know that I am correct, that at 2001, AUMF, it is, for all intents and purposes, expired. I'm certain we agree on that. And that's the reason that detail is negligible.
Well, Dr. Laporte, you are free to work with Delegate Grammer and Mr. McKnight to talk to the AG's office, okay?
We certainly will.
Thank you so much.
Thank you.
Any other questions for this panel? Delegate Martinez.
Thank you so much, Madam Chair. And thank you, Delegate, for bringing the bill. I think we all can agree that Congress isn't working, so I'm glad that the panel said that. My question is around some of the things that we've heard from our current president, particularly around immigration enforcement and sending our National Guardsmen to the border, potentially even overseas, to help with some of this enforcement. Would this bill prohibit that from happening? Is that something that you're intended on for this bill, or would that encompass that in this bill?
What type of enforcement?
Yeah, one person, one question.
I just want to understand the question more clearly, if you could.
So what is your
What type of enforcement?
For I guess, immigration enforcement, but also if we're sending people overseas to help or assist with that enforcement, would that encompass in this bill? Would the governor be able to say, no mas, no?
Yield to Mr. McKnight.
Oh, thank you. I appreciate that. Representative, I appreciate that question. This bill only interferes and stops the deployment for the purposes of overseas combat. The National Guard actually has a purpose in the Constitution to repel an invasion. And we've seen Attorney General Brenovich in Arizona, Attorney General Paxton in Texas. They've actually issued opinions that they think that what happened during the 2019 to 2024 time period might actually classify as an invasion. And so the National Guard could be used under governor's authority or congressional authority to repel that invasion. Now, that's a philosophical debate that's beyond this bill. What's happening at the border has nothing to do with this bill whatsoever, but the Defend the Guard Act specifically stops federalization for the purpose of going overseas for combat operations not declared by Congress. Now, every other purpose that the National Guard participates in, overseas training, overseas humanitarian efforts, domestic home security of the homeland, enforcement of local laws and federal laws inside of the continental United States, those all remain the same. Everything else the National Guard does, except participating in the Horn of Africa or Iraq or Syria without a declaration of war, everything else remains in place. To parlay this a little bit into what was asked about Raskin's bill in 2009, his bill stopped something or ended something that had happened incorrectly. This bill is much more powerful than that. It stops something from happening before it happens. And that's the benefit of state legislatures in our federalist form of government, is the duty to interpose between their own militia and an overreaching federal government. That's the whole point of the bill. So if there is an invasion on the border and it's not immigration related, let's say it's drug cartels, let's say it's criminals coming across the border, let's say it's an invading army, the National Guard's purpose from the Constitution is to stop that. Now, as far as the political ramifications of immigration, that's not what we're here to talk about. And all that does is probably muddy the water a little bit and divide lines. This is not a political issue. This transcends political lines. And I wouldn't want to interject immigration into the conversation about illegal war.
Well, I appreciate that sentiment. You know, unfortunately, from the places and intersections I sit, politics is always at the table. And so, you know, the issues that are of mine for my constituents are of immigration, are of overreach from the federal government. And so I really appreciate you seeing states as the front lines to an authoritative government that federally that's overstepping their bounds. Thank you, Madam Chair.
Delegate Rosenberg. And thank you, everyone, for being patient.
My question is for you, Mr. McKnight. If I heard you correctly, you cited one of the legal or people in support of your position was Lester Maddox. Is that correct?
No, I said that he is a governor that has used his own authority to interpose between a federal government call-up that he didn't agree with.
Okay, and how did he rise to prominence? Where did he take issue with federal laws, specifically Brown versus the board and its progeny?
They wanted to federalize the use of the National Guard, and he thought that it should have been a state mission instead. His was more about the authority to control the troops than it was about the purpose for which they were being called. It wasn't about the end result or the mission. It was about the proper authority. And ultimately, our country got it right. But his argument was that this is the state militia. I should be the one that controls them. I should be the one that is the commander in chief. And there's been debates for decades about the proper use of the National Guard for those type of measures. But ultimately, like I said, I think our country got it right.
Well, Mr. Maddox didn't think the court got it right in Brown versus the board because he used a pickaxe to prevent blacks from using his restaurant. Is that not correct?
That's an incredible point, and you're right. It's, again, taking the politics aside, his argument was that the governor is the commander-in-chief. And ultimately what happened was there was a proper authority given to call forth the National Guard. They relied on the three purposes found in Article 1, Section 8, Clause 15, to call forth the militia from the state to put down an insurrection, to enforce the laws of the Union, or to repel an invasion. Those are the three purposes, and ultimately, like I said, our country got it right by relying on the laws that we have on the books. The Constitution is the supreme law of the land, And by doing it with a proper authority, Governor Maddox, he may have interjected, and what he stopped was just an improper call-up of the National Guard through a DOD order, and they did it through a congressional call-up, which is the proper way.
Thank you.
You bet.
I don't see any other questions. Thank you so much for being with us.
Thank you.
Again, thank you for your service and your advocacy. I'm going to call an unfavorable, which is Craig Hunter from the Maryland Military Department. Good afternoon, sir,
Hi, good afternoon, ma'am.
and thank you for your patience. Welcome to the Health and Government Operations Committee.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Brigadier General Craig Hunter, and I thank you for the opportunity to testify in opposition to House Bill 548, the Defend the Guard Act. The Maryland National Guard plays a critical role in both state emergencies and our national defense, at home and overseas. Since 9/11, the federal government has invested heavily in the National Guard, enhancing personnel readiness, modernizing equipment, and improving infrastructure. These investments by the Department of Defense are based on the expectation that the National Guard units remain available to support our nation's national security needs. Restricting the Maryland National Guard's participation in federal missions could jeopardize this funding, shifting resources and modernization efforts to states that remain fully engaged. Beyond the financial impact, this bill challenges the fundamental role of the National Guard as a dual mission force. Maryland National Guard soldiers and airmen voluntarily serve both state and federal missions. Many actively seek federal deployments to gain valuable experience, career advancement, and active duty service time. Under HB 548, these opportunities would be restricted. Even though federal law allows for voluntary activation with both service member and gubernatorial consent. Additionally, the Department of Defense determines force structure and resource allocation based on the full availability of National Guard units. If the Maryland National Guard withdraws from the federal operations, our units risk losing priority in training, equipment upgrades, and overall readiness. This could weaken our ability to respond effectively to the state emergencies, natural disasters, and crises that require a well-trained force. HB 548 would not only limit opportunities for our service members, but also risk diminishing Maryland National Guard's capabilities. For these reasons, we urge the committee to issue an unfavorable report. Thank you for your time and your consideration.
Thank you for your time and thank you for your service.
Thank you, ma'am.
We really appreciate you. I'm going to open it up for questions right now from the committee. Delegate Riley.
Thank you, Madam Chair. Yes, thank you for being here. We appreciate it, and thank you for your service. We heard from the other panel, one of the gentlemen said that when someone goes and applies for the National Guard, that it is very clear that it is for Homeland. Is that not correct? When they apply, do they know that they could possibly be deployed overseas?
Yes, ma'am, they do. In fact, that is one of the things, if this bill passed, I would see recruiting being jeopardized because many of our recruits join because of that dual mission ability that we have. So they look for the opportunity to serve both at home and overseas. They can serve their home state and they get the opportunity to deploy and serve the nation. So I can see this bill hurting recruiting.
Okay, thank you very much. Appreciate it.
Any other questions? Seeing none, I want to thank you on behalf of the committee and thank you for your service.
Thank you, ma'am.
You have a blessed day.
You too.
Thank you. I'm going to go back to the favorable. I have Joe Obdyke, Garrett Sterling, Alexander Schlegel, Ali Rack, and Darren Gov, who is actually virtual. Can you bring it up, please? Did people leave? What is your name? Sir, your name?
My name is Alex Schlegel.
Okay. What is your name again?
My name is Alex Schlegel.
Okay, I have you. And you, ma'am?
Ally Rock.
And then where is Craig Hunter? Oh, no, he just testified. Garrett Sterling, are you here?
He is under the weather,
And Joe Updike?
not here.
Okay.
Not present.
All right, let's do it. And thank you for being patient as you waited.
All right, good afternoon, members of the committee. My name is Alex Schlegel, a Baltimore resident, Air Force veteran. Thank you for the opportunity to speak on behalf of this bill. In my time in the Air Force and also post, I've witnessed or heard the many stories from veterans, coworkers, the students I teach, close friends, and even my own family of the nonstop, unsustainable, unconstitutional deployments post 9/11 under the unconstitutional AUMF, Authorization of Military Force. Veterans, many here today that you heard, have all experienced at some level the tragedies, these endless, unsustainable, and unnecessary deployments and wars of the past 25 years. I'm one of the lucky veterans. I didn't see combat. And I thank God that fortunately I didn't have to suffer the tragic consequences, challenges, heartache, and circumstances many veterans and their families experience post-deployment, all of which could be avoided. This needs to end. You can all make the difference in this room. End the status quo. Force Congress to finally do their damn job. Great nations do not fight endless wars. The Guard needs to stay here in Maryland. Furthermore, the bill is common sense. We've all witnessed the recent tragedies of the Key Bridge, hurricanes that affected North Carolina, Tennessee, and Florida, wildfires in California, and just this weekend, there's flash flooding in Kentucky that's ongoing. In closing, this bill should not be partisan. It's your constitutional responsibility, everyone in this room, to commit on this committee to honor veterans and support this bill. Let's all lead from the front. Seriously, let's just do this. Do the right thing. And furthermore, and ultimately, blessed are the peacemakers, for they should be called children of God.
Thank you for your service. Next, please.
Madam Chair, Madam Vice Chair, thank you so much, members of the committee, for having us here today. My name is Ally Rock. I'm the Maryland State Director for the State Freedom Caucus Network. And actually, you're going to hear also from my colleague in Montana, who is happy to speak with you virtually today about the progress of the bill in that state. We strongly support HB 548 for its defense of constitutional principles and commitment to federalism, as you have in my written testimony. But since I know Madam Chair likes us to be fresh for our oral testimony, I thought that I would speak today more about why the title of this bill is dubbed Defend the Guard. Why does the National Guard, and specifically the Maryland Guard, need defending by the people of Maryland? After all, they are tasked with the defense of us, the American people in the state of Maryland. Why do we need to step up and protect the protectors? Since January 8th, I've been coming to the State House 3 to 4 days per week for the purpose of advocacy, and I'm struck by the artwork in the halls of the House office building here, particularly on the 3rd floor. But I'm embarrassed to admit that it took me a few weeks of walking the halls to notice that the beautiful charcoal renderings of the human subjects of the art project have a tragic meaning behind them. Chris Hipsley, Army, stoops to greet his service dog. Lenny Youngblood, U.S. Marine Corps, proudly bounces his toddler on his hip. Rory Patrick Hamill's haunting, solemn gaze, balancing atop his prosthetic leg, overlooks the business of the 3rd floor. They are all the faces of 22. The staggering statistic of the young men and women veterans who take their own lives each day in the United States. With PTSD being a leading underlying cause of veteran suicide, the most important thing we can do to prevent veteran suicide is to make fewer veterans from combat zones. We can hold Congress to their duty to put their names and votes to a declaration of war if it is truly a necessary last resort to defend our nation and our national security, and that is how we defend the Guard, who sacrificed so much to defend us. I urge the committee to issue a favorable report.
Thank you. Are there any questions for these two panelists? Seeing none, thank you so much for being with us today. Will you please bring the virtual witness? Is there someone here for this bill that did not get called? Will you please get up? Okay, please, the virtual witness. Thank you. Good afternoon, sir. Will you be so kind and unmute yourself, and we cannot see you? Mr. Mr.
Yeah,
Darren
Madam Chair,
Gup?
my name is
Yes.
Darren Gup. I'm unable to do video. I can only do audio.
It's okay, we will take
Okay.
it. Go ahead.
Okay, thank you.
You're welcome.
Again, my name is Darren Gobb. I'm a retired lieutenant colonel who served in the U.S. Army from 1991 to 2019. I have 7 combat and hazardous tours from North Africa to Europe to Central Asia, Middle East, and actually over into East Asia. I'm aviation branch as an officer, flew Black Hawk helicopters, but my generalist work as a general officer, as a military officer doing general kind of work is as a strategist and a planner who worked on Title 10, Title 32 Guard active and reserve components issues across multiple continents for the majority of my time. And today I remain a go-to person on anything military, foreign policy, and constitutional, and appearing in front of millions of people each week in the media. And I would tell you that I know, not every aspect. I know Dan McKnight of the Defend the Guard, but I do know many of the policies brought up. I'll skip through the majority of what I had to say because it's been said, and I agree with the proponents. What I will say and emphasize heavily is that this bill will not affect the following items. 1, funding. Your fiscal note, if it was honest, should say 0. I know that you have what's in front of you and that's all you have, but it should go back because there's no cost to this bill whatsoever. It will not affect force structure. Anything with bases or equipment, I've built force structure. This is just the case. It will not affect pay and benefits. It will not affect overseas training. It will not affect the commander-in-chief at the national level, his ability to rapidly respond to national defense priorities, or the governor's ability as commander-in-chief to use the state's National Guard to engage in things like drug interdiction or respond to emergencies. Unless, of course, your National Guard is overseas in an undeclared war, then they can't respond to anything your state needs. It will not affect readiness. The only reason why readiness would be affected by anything here is because your National Guard would lack leadership, and then you have a leadership challenge. Funding would not affect this because funding's not affected at all. Last thing I'll say is, and I'll get off, is that a uniformed service member, active guard or reserve, cannot appear before any legislature in this country and take a position on a bill, whether it be for or against. That is against DoD Directive 1344.10, and that should be known because it's a common thing in the military. We do not engage in politics. Every junior member of the military knows this, and so doing so is a violation of DoD policy. Thank you, Madam Chair.
Thank you. And if I may, and thank you for your service, the gentleman that testified, for the record, he signed up for the Maryland Military Department, not on a personal basis. And the record is very clear. Are there any questions for this witness? Thank you so much for your service again. We really appreciate it and for your patience. And this is actually the end of this bill hearing. We have called the witnesses. This is actually House Bill 548, the end of this hearing. That will conclude the bill hearing on House Bill 548. Next, House Bill 570.